All right, we have covered a lot of ground in all of these videos, and I wanted to kind of do a recap of where we find ourselves today based on the information that we originally started going through, some of the information that we were given, you know, by the John Galt person, or Juan Galt, and then where we think we are as of this moment. And the best way that I could think about doing this was to actually use an affidavit that I'm setting up, that I've already mailed a few of these things to the IRS, but I'm about to mail this one in as well. I'm essentially trying to get answers to these questions. So to be clear, I'm not suggesting that you follow my direction. I'm not suggesting that I have all the answers, but I am trying to get the answers. And one of the ways that I'm trying to do that is by sending the IRS questions, hoping that they will answer them. Now, I'm not stupid. I know they're not going to answer them, but I've got to try. Like some of this stuff is so blatantly unconstitutional that it really makes you wonder, you know, how they're getting away with this. And so all we can do is try, right? We may get nowhere, but I'm at least going to try. So in this affidavit, I've covered most of the stuff. I haven't covered all the little intricacies of, you know, the definitions and the terms and the code sections and all that in this affidavit, because I'm trying to keep it, you know, more constitutionally driven and straight and to the point. But watching the other videos, those are just additional things that we have issues with, but these are the big things. So let's take a look at this and see where we're at. So the first thing is that the Constitution is absolutely the supreme law of the land. It says so, and all the states signed on to it. And so we're establishing this fact up front, that the Constitution is the supreme law of the land, which means the Bill of Rights do apply to all, inside of all the states. All of that stuff is legit based on the Constitution itself. We also established the fact that our First Amendment right gives us the ability to petition the government for redress of grievance. And the reason that we're doing that is we're just making sure that they, you know, consider the fact that this is a grievance that we're petitioning them for, and that they are required by the Constitution to respond to it. They can't ignore us. If you remember, that's exactly why the Declaration of Independence got sent to the king, because he was doing the exact same thing to the people back then, except that he was king. Our government is not king. So it's, you know, it thinks it is, but it is not. So it says the first clause of the 14th Amendment states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. So the point here, it says the citizens this citizen is a creation of the federal government, and as such has no protections afforded to it by the Bill of Rights other than those contained in the 14th Amendment itself. The use of the words "and subject to the jurisdiction thereof" proves this out, as the federal government does not have jurisdiction in the several states except for federal matters. Alabama declaring that all persons in the 50 states are now considered citizens of Alabama and must therefore pay income taxes is no more legal than the federal government doing it. The federal government has no enumerated power that allows it to force state citizens into a federal citizenship. Unless a state citizen elects to naturalize into the federal government jurisdiction, this claim would have to be declared unconstitutional. So the 14th Amendment, and again, we can get into whether the 14th Amendment was actually ratified. We know that it was not, but it's there, and they've got case law on it now, so it's going to be hard to get rid of it. But we do declare that the first paragraph inside of that amendment is unconstitutional if they are wanting us to believe that we're all federal citizens, because we didn't elect to be a federal citizen. We weren't born in the federal government. And so the whole thing would require the federal government to do something that we didn't actually ask for. So it goes on to say the courts have ruled numerous times that the protections laid out in the 14th Amendment do nothing for state citizens, and that federal citizens created by the 14th Amendment have no protections from the first 8 amendments to the Constitution. If they were the same, there would be no reason to have a due process clause in the 14th Amendment. And this is very true, because if you were just going to automatically say that everybody born in the continental United States is by default a federal citizen, well, the first thing is you wouldn't needed to have put under the jurisdiction thereof, because that would have been that's kind of limiting something that was already covered by just saying anyone born in the continental United States. And then the other side of it is, why did you put a due process clause there when there were already due process protections in the earlier amendments? So those things taken together make you understand, or should make you understand, that there is something fishy going on with that 14th Amendment. And so it says, and there are Supreme Court cases, by the way, that do cover all this. And it says due process clause in 14, because we already had those protections. These two types of citizens are very different, one having rights and the other being given privileges. And that's because the federal citizen is a creation of the federal government. It's not, it wasn't born with inherent rights. It's something that they created, and therefore you don't have all of those other protections. And then this is just a declaration that I'm not a 14th Amendment citizen. And then it says Article 1, Section 9 says the migration or importation of persons as of such persons as any of the states now existing shall think proper to admit. So this in Article 1, Section 9 shows you that the states were always the ones that were admitting people into their state. And then it was up to the states as to whether or not they were going to allow them to become citizens. There was nothing anywhere that allowed the federal government to do that. And we'll get into that in the next one. It says Article 1, Section 8, Clause 4, to establish an uniform rule of naturalization and uniform laws of the subject of bankruptcies throughout the United States. This says that the federal government is to establish a uniform rule of naturalization. It doesn't say that they are the ones that are going to manage and allow people to come in and out of the country. There's nothing in the Constitution that gives them that power. The next thing, Article 1 says all legislative powers herein granted shall be vested in Congress of the United States. And so the reason for this is the only body in our country that has legislative abilities, which is, in other words, they can make laws, are the Congress and the House. There is nothing that provides the ability for the Congress and the House to hand that power off to the EPA or to the Federal Reserve or to whoever. There's nothing that gave them that power. They are the legislators. We elected them. We did not elect the EPA to manage our lives. And so allowing the EPA and the IRS and all these other agencies to go and create their own laws, or, you think of it this way, they were supposed to enforce the laws that we were to create. But in our situation, and I'll give you a perfect example, is property tax. The property tax is, there's limited code in Georgia, at least, for taxing real property. But what has happened is the legislator created something called the Department of Revenue, that is then responsible for determining how much tax everybody's supposed to pay. So there's nothing in the code that gives them that ability. They set up all these rules and processes for how they're going to calculate the value of property that's completely outside of what the legislature did. And we're saying that's unconstitutional. We didn't vote the Department of Revenue into being a governing agency in our country. We have legislators for that, and that's who we vote for. So they need to do the job if they want to tax our property or whatever it is that they want to do. So Article 6 further states the senators and representatives before mentioned and the members of the several state legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So every single public servant that is serving at any capacity is supposed to have an oath of office. That oath of office is the only thing that guarantees that the Constitution is going to be abided by. And without that oath of office, they can't hold that office. And so we'll just leave that there for the moment. The 14th Amendment, Section 3 states, no person shall be senator or representative in Congress or elected president or vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States, as a member of the state legislature, executive, judicial, all the same thing, shall have engaged in insurrection or rebellion against the same. No person shall hold office after taking an oath to support the Constitution, having engaged in insurrection or rebellion against the Constitution. It doesn't say rebellion against the country. It doesn't say, that they're trying to insurrect the country. It's talking about the Constitution itself, that if they war against the Constitution, they can't hold office. So it seems pretty straightforward. Number 10, the 14th Amendment, Section 4 states, but neither the United States or nor any state shall assume or pay any debt or obligation incurred in the aid of insurrection or rebellion. So and it says they shall be held to be illegal and void. So if your senator commits insurrection against the Constitution, in other words, he's not abiding by the Constitution in his daily duties, then he is forbidden to be paid by the state. And so it seems pretty straightforward. Number 11, law must be written clearly and concisely so that the public understands the requirements. The USC, UCC, and the IRC have been purposely, as well as the state codes, written to confuse the public and require bar-associated attorneys to represent them, proving that them all unconstitutional for vagueness. If you can't pick up the law and understand what your obligations under that law are, then it's void for vagueness. There's no, and especially when you can interpret it in multiple different ways. So you can't hold the public responsible for something that they can't themselves understand what the heck it's saying. And all it takes is anybody to pick up the Georgia code or the Virginia code or the federal code and try to read something on it and try to just tell me what it means, because it's written in ways that's so unnecessarily confusing that it makes one wonder. Number 12, 8 U.S.C. 1101A38, United States. The term United States, except as otherwise specifically herein provided, when used in a geographical sense, means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, the Virginia Islands of the United States, the Commonwealth of the Northern Mariana Islands. The reason I'm putting this in there is because I'm trying to make the point that Juan Galt said this, the United States always means the United States, period. So you can't, if it says in that one code section, the United States within geographical sense includes the District of Columbia, and that's all it says, he's saying, well, yeah, but the United States always includes the continental United States, so you just assume that that's what it means. My point here and what we're going to go through is you can't make that assumption. It's impossible to make that assumption, and I'm going to prove that. So number 13, 14 USC or 42 USC 960127 state. The term state or the terms United States and state include the several states of the United States, the District of Columbia, the Commonwealth of Puerto Rico, Guam, on and on and on. And then and any other territory or possession over which the United States has jurisdiction. So we'll leave that alone. Definitions throughout the USC are inconsistent and therefore require explicit wording. Assumptions of what is meant in one section or another cannot be relied upon. Assumptions of what the term United States means within the context of one or another code section could prove deadly. 14, 9 USC 307H, location of the United States. Now, this is, I think, the banking section. Location of the United States. The United States is located in the District of Columbia. So, again, we're not trying to make this code section has nothing to do with the IRS tax code. We're not trying to make the assumption that the United States is always one thing or another. What we're trying to show is that the term United States does not have a specific definition for us to assume that it means one thing or another. In every one of these code sections, it has a different definition and it includes different things. So this clearly says that this includes the continental United States, but then this one says it's located in the District of Columbia, which means it can't, in this section, it couldn't possibly mean the continental United States. So in code section 9, title 9, it doesn't mean the United States, the continental United States. It's something completely different. So you can't assume something somewhere else. Now, this is what they try to get us on: includes and including. The terms includes and including, when used in a definition contained in this title, shall not be deemed to exclude other things otherwise within the meaning of the term defined. So I submit that this was added just to confuse everybody, because anywhere you use the word includes, you first have to give it some group, and then you're including something into that group. That's generally the only reason that you would use it. If you only use the word include, then it is exclusionary and removes everything else from inside that group. For example, if I said, for the purpose of this recipe, fruit, the word fruit should or includes bananas and strawberries. Well, bananas and strawberries are fruit, but should I use grape in the recipe, or should I use oranges in the recipe? Because it says that anywhere I use the word fruit, it includes strawberries and bananas. So it's exclusionary in that particular sense. So I just, this whole include and includes thing, I think, was added in here just to confuse what otherwise would be saying what we believe it to be saying. So now 26, now we're in Title 26, 7701A9, the term United States when used in a geographical sense. Same verbiage that we had a minute ago, but it says includes only the states and the District of Columbia. Okay, so we could stop and we could say, okay, well, states includes the District of Columbia. States must be the continental United States, but it didn't say that, and we've already proven that the word United States they've used to be in the District of Columbia. So we can't assume what they're talking about. And then in the very next definition, they give us the definition of the term state in 7701A10, and it says the term state shall be construed to include the District of Columbia. It doesn't say the several states. It doesn't say the continental United States. And you just saw a definition where it included the continental United States. So it is my position, and I'm hoping the IRS can straighten me out on this, but right now I cannot make an assumption about what the word state or United States means, because they're using it in all kinds of different ways. So if you're going to say it includes the District of Columbia, then what else does it include? Does it include France, Germany? I don't know if you don't tell me. So I'm still of the opinion that 7701A9 could not possibly be talking about the continental United States. There's no way that it's talking about that, because there's too many other misconstrued facts that exist throughout the code where they're using those same two terms in completely different ways. Title 26, 1.911-2G reads, the United States, the term United States, when used in a geographical sense, same verbiage we just had, includes any territory under the sovereignty of the United States. That's interesting, because we're talking about sovereignty of the United States, and it says it includes the states. Now, is that the several states? It includes the states, the District of Columbia, the possessions and territories of the United States, the territorial waters of the United States, the airspace over the United States. Well, here's a question. You're defining the United States, but you're telling me that the term United States, when used in a geographical sense, includes the territory under the sovereignty of the United States. But the United States doesn't have sovereignty inside of the state of Georgia. It has sovereignty in D.C., and it has sovereignty in all of its areas. It can do whatever it wants in all those areas, but it cannot come into the state of Georgia and do whatever it wants. It doesn't have sovereignty here. So now it has a limited jurisdiction here over federal matters like banking and bankruptcies and those kind of things. It has limited jurisdiction, but it doesn't go into a state court and have a federal case be held. It would go into a federal court building that has been established for the federal government. So assuming that this paragraph is talking about the entire continental United States, again, is false. And them using the word state here is misleading because, again, they said state was the District of Columbia. They didn't say it was anything else. So all they're saying right here is that it includes the District of Columbia and the District of Columbia. And then every single other thing that they list here are all federal things. There's nothing in here that has anything to do with the several states. So it just makes one wonder. And again, maybe I'm misreading this, but I need somebody to explain it because it's written in a way that is extremely confusing to try to interpret. Article 1, Section 9, Paragraph 4. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. You cannot directly tax someone's income. Let me back up for a second. The federal government has the ability to tax pretty much everything. They can tax everything. But depending on the type of tax, there are limitations as to what that tax can do, how it operates. In the case of directly taxing property, they would have to have enumeration based on the census. If it is taxed on commerce or something non-direct, then that would be your interstate commerce and those things, and there's a way that it has to be done. So them claiming that or us claiming they don't have the right to tax property is not correct. They do have the right, but they have to follow these rules in order to do it. So then they came along and created the 16th Amendment, and it says the Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment among the several states and without regard to any census or enumeration. Now, here is the Supreme Court's ruling on this. So what they have done here is they've created the 16th Amendment to make it look like they had the ability to lay and collect taxes on incomes, but there's a number of problems with this section. The first is that they didn't define the word income. And so we have to go back to the courts or to the Black's Law or to a common dictionary to find out what the word income is, which is always a profit from a company. It is a corporate profit, and it is always based in money that they've made. So a corporate profit is paid in money off of the profit that has been made by that particular company. It is impossible for a person to make income because they don't have a profit. They get reimbursed for their services. So unless the federal government is coming along and saying that our labor is literally worth nothing, it has no value whatsoever, our labor is worthless, which if they are saying that, if that's their position, then now they're in violation of the 13th Amendment for slavery, because I'm not a slave and my labor is worth something. And so them trying to claim that it is worth nothing and that everything I make is to set off the initial value of my income, then we've got another problem that needs to be addressed, but we won't get into that here. But here's another Brushaber versus Union Pacific Railroad. It is clear on the face of this text that it does not purport to confer power to levy income taxes in a generic sense, an authority already possessed and never questioned. Again, they've always had the ability to levy a tax against your income. They've always had that ability. The question is how. And so it says, or to limit and distinguish between one kind of income tax and another. But the whole purpose of the amendment, and you have to remember too, the Supreme Court goes way out of its way to make sure it doesn't declare any amendments unconstitutional. They wiggle their way all through things and just redefine the entire code section to make it fit. They would never rule. They have never ruled that anything is unconstitutional. Anyway, and so it says the purpose of the amendment was to relieve all income taxes when imposed from apportionment from a consideration of the source whence the income was derived. So the Supreme Court says that they didn't get any new taxing power. They can't turn around and tax your income any differently than they were before. All the 16th Amendment did is it took all income and it made sure that it was all taxable. So all income from whatever source derived is all taxable. So that's the Supreme Court that has ruled on this. So they are not, and they go on, and if you want to go read this case, it gets into a lot of good detail, but they go on to say that the tax is a direct tax, and if it is taxed, then it has to be done through enumeration. So the 16th Amendment didn't give them the ability to go tax it any differently than they always were. It just said all income is now going to fit into however they end up taxing it. So an interesting court case to go read. And so Eisner versus Macomber 252, Congress cannot, by any definition it may adopt, conclude the matter. And it's talking about the definition of the word income, since it cannot by legislation alter the Constitution, from which alone it derives its power to legislate, and within whose limitation alone that power can be lawfully exercised. So in other words, they've passed a constitutional amendment that used the word income, and the legislature cannot now go try to give that word some definition. And that's why you don't really find a definition for the word income in the IRS tax code. It gives you gross income defined, but it defines gross income as income. So you don't, obviously income would have covered everything that adding the word gross to it didn't do anything to the actual word. It's like having, saying something like all horses are four-legged animals, and then coming back and saying gross horses are horses with four legs. It doesn't tell me what a horse is. It's all it's doing is saying all horses fit this description, but it doesn't really tell me what the heck the horse is. Maybe a bad example, but hopefully you get the point. And so, and this is the Supreme Court case again. It says, after examining dictionaries in common use, and it gives you some of the ones that they used, we find little to add to the succinct definition adopted in two cases arising under the corporation tax of 1909. And this is before the IRS got formed in 1913. And then it gives you another Doyle versus Mitchell Brothers. Income may be defined as the gain, what you made in addition, derived from capital, from labor, or from both combined. So it's the gain that you got in that execution. So example, I have a company and I charge $50. Let's think about a lawnmower dealer. He charges $50 for the mechanic to go work on your lawnmower. But the lawnmower dealership only pays the mechanic $20 an hour. So the lawnmower dealership is making $30 profit off of that labor. but that mechanic didn't make anything extra off of the labor. He is getting reimbursed for his time. So unless the IRS, again, is claiming that his time is worth absolutely nothing and they are participating in slavery, or this thing doesn't apply to him, his wages and his reimbursement don't have any effect. 22, taking liens against state citizens' property and confiscating the contents of their checking accounts without due process of law is a direct violation of my constitutional protections. In addition, there must be legislation granting you the right to do this, and I cannot find any. Title 26, 6331, Levy and Distraint. It reads, and I'm going to skip all of the mumbo jumbo. It says, levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States. And I want to preface something, and I get into this in a second, but of the United States, an employee of the United States. It does not say an employee in the United States. It says an employee of the United States. So they can only levy that which they have control over. And then it says, as previously demonstrated, let's see. I'm going to skip my diatribe here. Continental. Okay, so by the IRS, that employees of the United States includes any person working in the continental. So this is their argument: is anybody working in the United States is subject to this. But again, they use the word of and not in. Levy may be made upon the accrued salary or wages of any person working in the United States would have been a better way to put it, but that's not the way they wrote it. They said of the United States. For a lien to be placed, one must first prove that a tax is owed and provide a law that allows you to make such a determination. If you are making the determination by reviewing my checking account, then I would also assume you had a warrant to do so. See, we allow these people to do things or to claim they're doing things that are so unconstitutional that it makes your head get dizzy. If they are going to go get access to your bank account for the purpose of determining whether or not you owe them money, well, they need a warrant to do that. They are going to have to accuse you of a crime. What is the crime? I don't know what the crime is because there's no law in the books that says that I have to pay income tax. So what is the crime? Go to the court, get a warrant, and then go to the bank and get the thing based on a warrant, not by giving them some code section that doesn't even say what they purport that it says. So this whole thing has got so many holes in it that it is insane that it's held water for as long as it has. So requiring someone to provide their personal papers is a direct violation of their Fourth Amendment rights. So you know that if you give the police officer this piece of paper that you're going to go to jail, and they are telling you that you have to give him that piece of paper, well, that violates your Fifth Amendment rights to protection of not to bear witness against yourself. If they want that piece of paper, then they need to go get that piece of paper on their own. So the point is we have, constitutional protections for a reason, and we need to start standing up for them because all of these things are insanely written, and they're written to confuse us because there's no other way to look at this. So let me get back. I messed up and hit a key. Where was I? That's liens. All right, so 23, for a lien to be placed. Okay, that's where we just left off. So 24, requiring someone to provide their personal papers is a direct violation of their Fourth Amendment rights. Again, we have a Fifth Amendment right not to bear witness against ourselves, and they are telling us if we report anything on our income tax statements that we could go to jail. They're forcing us to report on ourselves and know that we could go to jail. So, somebody claiming, in fact, the John Juan Galt, he brought this up. He's like, you don't have Fourth Amendment or Fifth Amendment rights unless you're accused of a crime. Well, I disagree with that because if if you don't have Fifth Amendment rights, unless you're convicted of a crime, then that would mean that you have to give your documents to the police officer just because he asked. No, there's no crime there. I have to give him anything he asks, no matter what, even though I know that he's going to build a crime against me if I give him the piece of paper. That just doesn't make any sense. So I disagree with the fact that you don't have Fifth Amendment rights, Fourth and Fifth Amendment rights, unless you're accused of a crime. That's just ridiculous. So again, requiring me to fill out a form with a statement of perjury violates my Fifth Amendment rights. To me, it's pretty straightforward. 26, because of the fact that income was not and cannot be defined by legislation, it would seem a good idea to refer to Black's Law, which states the return in money from one's business, labor, or capital invested, gains, profits, salary, wages, etc. Return is defined as a profit on sale or income from investments. Money is defined as in the usual and ordinary acceptance. It means coins and paper currency used in circulating medium of exchange and does not embrace notes, bonds, evidences of debt, or other personal or real estate. So we've got another video that we went into depth on that whole money thing. So 29, all federal forms used to collect information are required to contain a valid OMB number. Now this is another, here's the thing that you really need to get in your head. There are so many things wrong with the tax code as it's written that you have to at least be able to back up and ask yourself, how in the world could you be responsible for having to deal with all this stuff when there's so many different holes you can stick your finger in? It's insane. All federal forms have to have an OMB number. That OMB, so per 44 USC 3507G, this is the OMB stuff. The director may not approve these numbers and the collection of said information for a period longer than 3 years. That means an OMB number on a form can only exist for 3 years unless they renew it. So we'll just leave that at there. 44 USC 3507H3 states that an agency may not make a substantive or material modification to a collection of information after such collection has been approved by the director unless the modification has been submitted to the director for review and approval under this chapter. In other words, they can't change the form. Once they get it approved, they cannot change or make material changes to that form without getting approval from the director. Seems pretty straightforward. Here's where things get absolutely insane. The OMB number on the 1040 is being used on multiple other IRS forms. So here's the interesting thing. Since the OMB number specification came out and they had to start putting these numbers on there, the IRS 1040 form has had an OMB number. That form has had that exact same OMB number for the entire time. The approval process that was supposed to have been done to get that OMB number was never completed. There's no evidence that the process was followed by the IRS, because in order to get the OMB number, they have to supply the law that requires the citizen to supply that information. There is no law on the books that says that a state citizen, has to pay an income tax. There's no law. So they had a problem. So they worked around it and they got the OMB number to trick everybody. But the problem is that same OMB number, each form that collects information is supposed to have a separate OMB number. That same OMB number is used on a multitude of different forms. Let me see if let me look over here and see if I can find real quick. See if I can find the website. don't remember. I don't want to take up too much time. There's a website that you can actually go to that will tell you the, let's see if this is it right here. Yeah. So this is this it? No. This is the Office of Management Budget website. Anyway, that's their agencies. This is the search page. Yeah, I don't have it right here in front of me, so I won't waste too much time on it. But the point is they have a website that they actually list out the form, when it was requested, its expiration date, and all that kind of stuff. Every one of the 1040 form, the OMB number is used on like 15, 20 different forms, and they're all expired. And they've never been put up for renewal, which means that form, it does not contain a valid OMB number. So it says 44 USC 3512 states clearly that there can be no requirement to file paperwork that does not contain a valid OMB number. And I submit the 1040 is one such document. So even the document that they're telling you has to have an OMB number on it, it doesn't have a valid OMB number. And in their own law, it says that you're not required to fill out any form that doesn't have a valid OMB number on it. So I don't know how much simpler it can be. The IRS and the privately owned Federal Reserve Bank have made it illegal to deal in money and force us to use debt instruments instead. As a result, it is quite impossible for anyone to make income. If debt instruments, notes, cannot be classified as money, and we're all being reimbursed, or we're being offset with a bunch of IOUs, then how on earth could we say that we're making income? It's just another problem that we have with this particular situation. So again, I could make this video a lot longer, and we could go through all the different code sections that have all these discrepancies. We've done that in earlier videos, but this is, like, to me, the most cut down, isolated example of why income taxes have to be illegal. And if they're not, give the IRS the ability, and I'm also going to send this to the Georgia Department of Revenue as well, because I don't really care who responds to it. I just want some explanation. There's plenty of questions here. There's plenty of confusing things here. Maybe I'm wrong. Maybe I do not understand what in the world this stuff says because I'm not an attorney. That's what they like to tell me, is I'm not an attorney. I'm not smart enough to comprehend what these things are actually saying. And so, if you want to screw around with us, we'll put you in jail. That is not an explanation, and that is not a redress of grievance. And so I'm sending this to people under oath so that they can respond accordingly. I have put them on notice that they are under oath and that they cannot serve in the position that they're in without responding appropriately. I've also, in the first paragraph of this thing and in this paragraph here, I have put them on notice that they need to respond in the same way that I have responded. I've given them an affidavit stating what I think the facts are, and if they rebut any of these facts, then they need to actually do so in a similar fashion. So hopefully I'm going to get some information back, and we can go from there. I don't know how in the world they would refute any of this stuff because I've been researching this for quite some time, but we'll just kind of see what happens. But that's the current state of affairs related to income taxes.